Hi, I'm Tony Nunn and I'm the National Sales Director for the Charles Darby Mortgage Bureau. Welcome to Module 4 of this series of protection planning modules. And if you have already watched the first 3 modules, you will understand the implications of not having any protection, what the state does not provide, and what tools you may have in your toolkit to provide a solution. This module looks at case studies, with each becoming more complex, and puts all that we have discussed into practice and allows us to give the advice. So let's have a look at case study 1 and a couple that we met in module 1, but perhaps with a bit more information following your fact-find meeting with them. So it's Mr. and Mrs. Ordinary, married with no children, both aged 30. Mr. is the plumber, employed on £30,000 per annum, and Mrs. is a primary school teacher, employed on £28,000 per annum. They're first-time buyers, looking to purchase a property for $220,000, and they've got a 5% deposit. So having looked at the overview, let's have a look at what they have by way of employer benefits and protection already in place. So firstly, Mr. Ordinary. He's got a workplace pension, but he's chosen to opt out. He has no death in service benefit, and he only has statutory sick pay available to him. Mrs. Ordinary has a superannuated pension scheme, 4 times death in service benefit, and 6 months full pay and 6 months half pay in the event that she can't work due to illness or accident. Through the process of fact-finding, you uncover that they have no will, as they thought they were too young, and Mr. opted out of the workplace pension as he felt that saving for the house purchase was more important. They have some disposable income, but it will be tight, and they have every intention of starting a family within the next few years because of their age. Accordingly, they want to save what they can for starting a family. There are no other contractual debts outside of the norm, i.e. mobile phone, credit card, car insurance, etc. So applying what we've learned to date, what concerns might we have for this couple, and therefore what should they consider? Let's start to build the case for protection planning. The first thing to consider from an advisor's perspective is life stage. Remembering the 7 stages from module 1, they are in the paying bills range, which when you look at the story to date seems absolutely to be true. And so it will be about surviving through any hardship that may manifest itself via an unforeseen event. So on what legal basis will we arrange the mortgage? Joint tenancy or tenants in common? What do they have available to them from an employer's benefit perspective, and what will the state provide, if anything? Is a will necessary at this point in their relationship? So taking each of the above points into account, the following is decided. Given the paying bills stage of their life and the importance they place on getting onto the property ladder, as there never seems to be enough month left at the end of their salary, can they afford any disruption to their income? Believe it or not, death is the least of their problems. It is more likely that loss of income will be the killer. Mr. Ordinary in particular is the main concern, as he only has statutory sick pay available to him, and so we know from module 2 that this will pose a problem because he may only receive £89.35 per week if too ill to work, and will only be paid by his employer for up to 28 weeks. Statutory sick pay is not enough, and too short if it is a long-term incapacity or illness. Even Mrs. Ordinary's income into the family unit will suffer post 26 weeks, as she drops to half pay, and after 52 weeks has nothing to rely on. But perhaps the state will pick up the shortfall by way of available benefits for long-term incapacity. We know from module 2 that this is not something to rely on, as we learned that personal independence payment may be payable as she's aged between 16 and 64 and could get between £22 and £141 a week, but it's dependent upon how any condition affects the individual and not the condition itself. So this will largely be dependent upon the outcome of an assessment with a health professional and how you can perform daily living duties. And whilst long term they may both qualify, is this really something to rely on? Moving to the legal aspect of this pending house purchase, in my opinion, joint tenancy is the probable route to go, as there does not appear to be any other factors in the equation that would suggest otherwise, i.e. there are no previous children from previous partners to consider, and so this removes the necessity to divide up assets equally should this couple indeed feel it necessary to do so in the event that there was an offspring. And there is nothing from a tax perspective to take into account. After all, it's a residential transaction and not a buy-to-let. And so no investment income is being derived, and their feelings post-fact finding are that they should both retain the asset for 100% in the event of a predeceasing spouse. So, joint tenancy it is then. We've discussed the sick pay arrangements in life stage, but Mrs. does have death in service benefit payable at 4 times her annual salary. So bearing in mind that the disposable income may be tight, can we use this in any way? I think the question is more like, should we be using this in any other way other than for the purpose it was designed for? From Module 2, we talked about the possibility of further tax implications, but we can already see that this will not be the case. So what about the portability of death in service? If this couple have designs on family planning, which they've told us they do, then this benefit may well be lost. Will Mrs. leave her role to become a house person? Probably not, as they need the income. But what about if she returns to work in a lesser capacity? This may be an issue, as she may return to term time only, in which case her salary will drop, and in which case so will her death in service calculation, which would then lead to a shortfall if you had used it. The point being that this type of benefit is about helping a surviving spouse cope with life for a time following the loss of a loved one. It is not to support large loans such as mortgage, as invariably it's not enough. It's not a constant, as it's contractual, and more importantly, it will be removed completely from the equation should you become long-term incapacitated, as at some point you will no longer be employed. Remember, death in service is generally 4 times salary, and so 4 years of salary introduced into the family unit bears no comparison to a mortgage contract, which in this case is probably 35 years. And so what about the other 31 years? There is more to financially running a household than just the mortgage payment. Would it not be a tragedy if you became long-term ill, had your employment terminated, and at some point, due to this fact, and then passed away and had no cover whatsoever? Let's look at will writing. This, in my opinion, is hugely undervalued as a form of protection and is generally viewed as something old people do. And before you ask, yes, I do have one, but it's not because I'm old. So if the mortgage is written as joint tenancy, then the rules of survivorship apply, and so the asset will pass to the surviving party named at land registry via the deed. Great! That's the end of that then. Well, actually, maybe not. What if they've not made a will and both deceased as a result of an accident? The law states that in this instance, the youngest of the couple will be deemed to be the surviving spouse, and so the asset will pass to them, but because there is no will, the rules of intestacy will apply, and so the entire estate will be split among the surviving spouse's relatives, according to these rules. Well, that doesn't seem fair, does it? Didn't both parties contribute equally into the marriage and the acquisition of the asset? Why should it all go down one bloodline? Why indeed? It's because those are the rules, and if no surviving relative exists, it goes to the Crown. And that really is not fair. Conclusion: if you want to be absolutely sure that your estate is distributed in the way that you would like it to be, then a will is an absolute necessity. Please bear in mind that when dealing with clients outside of England, such as Scotland, the rules may be different. So what advice are we giving? Without being product specific, I believe that the advice to be delivered is as follows. Joint tenancy, as it deals with the distribution of the largest asset forming part of each individual's estate in a way that they have expressed they would like it to. Mirror wills, detailing how they would like their estate distributed in the event of them both deceasing simultaneously. It simply dictates their wishes without any state intervention. And alongside their capital and interest repayment mortgage, I would advise that a joint mortgage protection plan be purchased for 100% of the outstanding mortgage advance, including any arrangement fees that are likely to be added to said advance, and including some form of critical illness, serious illness, or terminal illness as agreed upon. This is to remove the debt entirely on diagnosis of any of the covered definitions pertaining to illness or in the event of death. For Mr. Ordinary, I would strongly advise that a form of income protection is purchased with a deferred period for benefit according to what might be affordable to him and set to his expected retirement age and in all circumstances, preferably post-mortgage term. If this type of policy needs to be set for a deferred period of 26 weeks perhaps, as it is simply not affordable before then statutory sick pay should be taken into consideration and he should then be advised to save any shortfall via a savings vehicle so that there is enough in reserve to allow him to get to the chosen deferred period, safeguarding against any financial hardship prior to benefit inception. For Mrs. Ordinary, I would strongly advise that a form of income protection is purchased with a split deferred period for benefit, tapering into and utilising what she already has by way of employer benefit. This is to take up the shortfall at 26 weeks to 52 weeks when her employer drops her to half pay, and then from 52 weeks full benefit as her employed income will drop at this point. My top tip when delivering advice is to deliver it, even when it's obvious that affordability might be an issue, as it really does serve to illustrate to your client exactly what they need in an ideal world and how big the problem could be. It is then about agreeing conceptually what you've discussed and, of course, your resulting advice, and agreeing what is a priority for now and what you can work towards improving at subsequent reviews, and indeed as their circumstances change. In my experience of advising clients, it gives a purposeful agenda to every meeting that you'll ever have with these clients ongoing, and merely plants the seed going forward for them as to what's important to them. And dare I say it, the discussion then becomes about what they can afford and not whether they should have it or not. So let's see what the annual review for this couple might look like. If we catapult this couple ahead by a couple of years and include a child into the equation, the advice may not change dramatically depending upon what decision Mrs. Ordinary took with her employment. If she went back to work full time, then it would be about tweaking the advice around family planning now that there is a child and taking into account any additional costs that may have been incurred for child care, etc. So what considerations would there be? Revisiting any recommendations that were not taken up, if any, from when they last received advice. The legal aspect, joint tenancy, would have been dealt with at the outset, and so whilst it's possible to look at it again, this should not be necessary. Should they have agreed with the recommendation to write a will, it may now need to be reviewed as there is a financial dependent. The issue of legal guardianship may need addressing, and also the redistribution of some of the assets making up the individual estates. And if they hadn't made a will, perhaps now's the time to consider it. No need to dislodge the mortgage and protection plan if they took it up, as it's doing its job unless there's a need for further borrowing. However, if they did not take it up, then there is a heightened need for it now that there is a financial dependent to cater for. With regard to the individual income protection plans, if they did not take these up, then now's the appropriate time to look at them due to the arrival of the financial dependent. And if they did take them up, how has the income changed, if at all? If it has, then it's time to top up. At this point, having addressed the agenda that was set at the time of purchase as part of the advice process, it's also time to consider a new protection product to address the arrival of the financial dependent. The new issue to consider will now be those pertaining to safeguarding the child and its future against unforeseen events and implications of death or illness for its parents. If the clients had done everything proposed at outset, there might be very little to contemplate in this regard. However, it will beg the question that should the mortgage be redeemed due to a policy payout, will the remaining spouse, providing there is one, be able to cope financially now that there may be additional costs involved in raising the child? Childcare is the likely cost. Otherwise, it may mean a change of occupation for the remaining spouse to cope and a change to income now being received, which is likely as a result of less time working to cater for the dependent. There will be a variety of solutions, but with one eye on cost, a family income benefit plan may be the answer. Aside from reviewing what products are in existence and tweaking them appropriately, it may be appropriate for them to purchase a family income benefit plan, as it will allow them to cater for the costs pertaining to childcare should either one of them predecease the other. So the advice might be to purchase a family income benefit plan with the sum assured being equal to the monthly cost of childcare for an agreeable term whereby eventually the child becomes non-dependent from the perspective of not requiring childcare. Most likely a policy term for the child attaining age 15 to 18 years, depending upon the discussion had. If the income position has not changed significantly since the last review, it may be that affordability could be a barrier. In this instance, I will revert back to my days on the road and an expression that I use to great effect. All parents receive child benefit, which is currently payable at £20.70 per week and payable until the child attains age 16. And the saying was, let your child benefit your child. What greater way than for the government to pay for your child's safety and welfare than to fund a policy that does exactly that and for a monthly benefit way in excess of £20.70 per week. Do a quote and see for yourself. Well, that's Module 4, Case Study 1. Watch out for Case Study 2, and thank you for listening.